5 seconds to go. Start. The basis on which the High Court directed this threefold division was its finding of joint possession. Justice D.V. Sharma decreed the entire property to the plaintiffs in suit 5. The common thread that runs through the judgment of Justice S. U. Khan is that Muslims and Hindus were in joint possession, and since under section 110 of the Evidence Act, title follows possession, both were joint title holders of the premises in dispute. The basis of Justice Sudhir Agarwal's judgment can be delineated thus. Muslims did not have possession of the outer courtyard at least from 1856-57 when the dividing railing was raised by the British. Muslims have had at best only a right of passage through the outer courtyard. The possession of the Hindus over the outer courtyard was open and to the knowledge of the Muslims. This is evidenced by the documents of 1858, which indicate that the Mutawali of the mosque had made several complaints, in spite of which the structures continued in the premises, as did the entry and worship of the Hindus in the outer courtyard. There is no evidence of the Muslims being in possession of the property in dispute, while it cannot be held that the Muslims did not visit the inner courtyard at all, or that no namaz was offered till 1949, that by itself will not amount to possession in law. There was a beneficial enjoyment by the Muslims with the Hindus, and the Muslims thus visited the inner courtyard for worshipping in their own way. Though there is a claim of the plaintiffs that since regular namaz was offered in the inner courtyard, the receiver would have recovered requisite material relatable to its use. No such material was found, leading to the inference that none existed. This weakens the claim of the Muslims to exclusive possession in the form of continuous worship. The Muslims did not abandon the property in dispute. They continued to exercise a claim over it, getting it recognized by the British government in the form of a grant for upkeep and maintenance. The maintenance of the building to the extent of the disputed structure and the partition wall is evident, as is the entry of Muslims into the inner courtyard for namaz. While both the Hindus and Muslims visited the disputed property as worshippers, the only distinction was that Hindus visited the entire property while Muslims were confined to the inner courtyard for the purposes of offering prayers. While Muslims have failed to prove that the property in suit 4 was in their exclusive possession up to 1949, both the communities were in possession of the inner courtyard. The outer courtyard was not in the possession of the Muslims as of 1949 and even prior thereto. Insofar as the inner courtyard is concerned, the Muslims have discontinued their possession from 23rd December 1949. Prior thereto, the possession of the inner courtyard was enjoyed by both Hindus and Muslims, and Hindu religious structures existed in the outer courtyard since some time after 1856-57 and were being managed and administered by the priests of Nirmohi Akhada. Therefore, to the extent of the outer courtyard, the disputed site can be said to have been in possession of the Nirmohi Akhada, while the Muslims ceased to have possession over it. The inner courtyard was not in the exclusive possession of either of the parties, and it was visited by members of both the communities without any obstruction. in allowing the entirety of the claim of the plaintiffs in suit 5, Justice D.V. Sharma held, a mosque loses its sacred character upon being adversely possessed by a non-Muslim. Stop.